Hello everybody, my name is Martin Jarrett and I am a Senior Research Fellow at the Max Planck Institute for Comparative Public Law and International Law, and today I'd love to present on this topic right here, the protection status of fossil fuel-based investments under international law. Let me first give you a little bit of background and I'll introduce my research question. The critical narrative on the Energy Charter Treaty, which is one of the main investment treaties that governs the protection of fossil fuel-based investments. In the media over the past few years, there's been a fairly critical narrative about the Energy Charter Treaty, as demonstrated by this article right here. A little-known EU investor dispute treaty could kill the Paris Climate Agreement. I've taken this article from Forbes.com. I think this is a really interesting part just here. I've underlined it for us. They, NGOs, say that it, the Energy Charter Treaty, is preventing countries from putting in policies to phase out fossil fuels in order to meet the targets of the Paris Climate Agreement, because they risk being sued by fossil fuel companies if they do so. In other words, the regulatory changes needed to meet the Paris Agreement goals will be impossible as long as this treaty is in effect. If this is true, it's fairly serious stuff, and it prompted a reaction. And the reaction was to modernise the Energy Charter Treaty. Now, the modernisation of the Energy Charter Treaty means a lot of different things, but in light of the narrative that we've just spoken about, i.e. that the treaty is obstructing the energy transition, it particularly meant changing the definition of the word investment in the Energy Charter Treaty. Here is the definition here. Yes, I know there's a lot of words on the screen there. You're not meant to read all of them. We're only going to focus on these ones here. Energy refers to any investment associated with an economic activity in the energy sector. Okay. And an economic activity in the energy sector means an energy activity concerning the exploration, extraction, refining, production, storage, land, transport, transmission, distribution, trade, marketing, or sale of energy materials and products. All right then, so what are energy materials and products? Very quickly, nuclear energy and also coal, natural gas, petroleum products, and electrical energy. So I think that the main thing that I really want you to pull out of that definition is that in order to have a protected investment under the Energy Charter Treaty, you need to have your investment connected to one of those energy products. Fine. You'll notice there's a good coverage for fossil fuels in there, and it was an ambition among quite a few states to the Energy Charter Treaty that are parties to the Energy Charter Treaty to change that, as this document here shows us. Consultations on the modernisation of the ECT. Let's look into the language. We're interested in what comes below here. In addition, the ECT annexes on energy products and materials, i.e. what we just spoke about, nuclear energy, petroleum products, etc., could be updated, and the definition of economic activity in the energy sector, which is relevant to the type of covered investments under the ECT, could be clarified. This is diplomatic language, of course, but roughly translated, I think that it means, 1, the list of energy products has to be expanded, and 2, some fossil fuels may need to be excluded. And indeed, that's eventually what transpired. In June, the contracting states of the ECT reached an agreement in principle to modernise the Energy Charter Treaty, and they released this document to give us a few previews of the changes that we should expect. Again, we'll zoom in. Pillar 1 basically says that the list of energy products has to include the 5 noted ones there in the future: hydrogen, biogas. You can see the others on the screen there. Pillar 2, I think this one's really interesting, the flexibility mechanism. It allows states to exclude investment protection for fossil fuel-based investments in their territories, which I take to mean that states can eliminate fossil fuels from the definition of investments. The EU and the UK have indicated they will take this option. So, in light of all that, the research question is this one here. How effective will this reduction in the protection status of fossil fuel-based investments actually be? In other words, will fossil fuel-based investments still somehow, some way manage to find protection under international law? To answer that question, let's examine the details of the new regime created by the Energy Charter Treaty. We can sink our teeth in a little deeper into Pillar 2 here. I'm not going to read this all out. If you wish to read it while I'm speaking to you, or you can simply pause the video and read through it, please feel free to do so. I want to only point out two matters here. First, when a state elects to stop protecting fossil fuel-based investments, that election only comes into force with respect to, let's call them already made investments, 10 years after the new Energy Charter Treaty takes effect, whenever that will be. We hope soon, but 10 years after that date. As regards new fossil fuel investments, and that is fossil fuel-based investments made after 15 August 2023, they will get no protection at all if a state decides to opt out. In other words, if one state or more simply says, we will exclude fossil fuels from the definition of energy products, which ultimately means investments that are connected to fossil fuels will not be protected in those particular states. I have some open questions. First one, what is going to be the definition of fossil fuel? Will peat be included? Will uranium be included? Uranium should not be included. It's not a fossil fuel, but perhaps there will be political pressure to include it as a fossil fuel. What about the issue of taking away investors' rights? Of course, some investors will look at this and say, well, we did have protection, now we don't, we didn't agree to that. States can't take away our treaty rights like that. If, however, you're ready to subscribe to that type of argument, you have to come to the view that investors have direct rights under treaties. And I think most people would say that they do not. They only have derivative rights. So that shouldn't be an issue, although it's something that I think will need to be clarified in the final document, the final ECT 2.0, let's call it. Finally, I want to talk about calculating damages. And because this one is a little bit complex, I thought I might give an example to explain exactly what I'm concerned about. So let's imagine we have a fossil fuel-based investment and it's made in the year 2020 with a projecting operating life until 2045. Under the ECT 2.0, it has protection until, let's say, 2033. And in 2030, a state breaches the ECT. And let's imagine that this state has also opted out of protection for fossil fuel-based investments. How should the damages be calculated in respect of this type of breach? You have one option. You can give the arbitrators can calculate damages on the basis of the cash flow of the operating life of the fossil fuel-based investment, in other words, until 2045. Considering, however, that after 2033, the same investor would have no claim at all under the Energy Charter Treaty, there might be a case or an argument to say, wait a minute, the investor can only get damages measured up to 2033, or finally, the investor might get book value. So this is one issue that I think the drafters will need to address when they put pen to paper and start writing ECT 2.0. Let me have just one final comment here, and it is this. An exception needs to be made in cases where a state which has taken the opt-out option, in other words, for it, the definition of investment does not include fossil fuel-based investments, continues to operate the investment. And because I think this is so important, let me play around a bit by adding a few exclamation marks. Here's an example of what I'm talking about. Let's imagine that the protection for a particular fossil fuel-based investment under the Energy Charter Treaty runs out in 2033. Exactly at that time, or even at some point after, a state decides that it will expropriate the investment. And then it continues to operate that investment. So you can imagine if the investment is an oil field, the state comes in, expropriates it, and continues to produce and develop the field. Well, obviously carbon emissions are going to still end up in the atmosphere, which is ultimately the point of excluding fossil fuel-based investments from the definition of investment. So in that case there, we do need a solution to this problem. I would suggest giving the investor some type of defense that it can plead. And essentially, with that defense, it can say to a state, you can't rely on this opt-out option that you've taken. Because you can't rely on it, the investor can still claim compensation. All right, so there are a few issues with the new Energy Charter Treaty, which I hope that the drafters might be able to give their attention to. There is also another issue on the horizon that I think that we need to deal with, and that is the protection status under other investment treaties. First, let me give you a clarification of the issue, particularly using the United Kingdom as my example. It will apparently opt out of protection for fossil fuel-based investments in the new ECT. The thing is this: the UK still has 20 in-force investment treaties with other parties to the new Energy Charter Treaty, ECT 2.0. So now what we need to ask is this question here: will fossil fuel-based investments still be protected under these other investment treaties? To make sure that they don't, the main solution to this particular problem would be to include an explicit provision in the new Energy Charter Treaty to the effect that the definition of the word investment in the new ECT also applies to other investment treaties between the UK, for example, and other states with which it has bilateral investment treaties. Now, if there is no explicit amendment of these other investment treaties by the new Energy Charter Treaty, then we have to think about the second option, which is this one here, an implicit amendment of these other investment treaties. So an argument would need to be developed here by a state, probably in the context of an investment treaty arbitration. The argument would go something like this: because there is a new definition of the word investment in the new Energy Charter Treaty, that investment comes across and is imported into these other investment treaties, and because of that, then the definition of the word in those other investment treaties is now the same as what we have in the new Energy Charter Treaty. Exactly how that argument can be made, honestly speaking, I haven't fully thought through. Of course, it will ultimately be based on this treaty here, the Vienna Convention on the Law of Treaties, and I strongly suspect that these provisions here will be very much in focus. I'll underline them for you so you can see exactly what I'm talking about. Very well known rule: there shall be taken into account, together with the context, any relevant rules of international law applicable in relation between the parties. Let me give you some of my concluding thoughts and then we'll finish up. Here are the issues going forward, I think. Issue number one, I would love to see the drafters of the new ECT think about the issue of calculating damages when a state decides to take the opt-out option. Second thing is, I think there needs to be an exception in situations where a state simply expropriates an investment. That state has taken the opt-out option and then continues to operate the same fossil fuel-based investment. And the final issue that the drafters need to think about is this one here. Does the new provisions or the new details on the definition of the word investment in the new ECT, should that be amending the definition of investment in other investment treaties? So that's it for today. As always, I'm always happy to read any comments that you have on my thoughts. I'll always reply to them. You can leave your comments down below, or you can write to me via email. And until my next video, thank you very, very much for watching.